Good morning, Chair Shields, Vice Chair George, members of the committee. My name is Keith Dubanevich, and I'm Chief of Staff and Special Counsel to the Attorney General. Thank you for the opportunity today to talk about what has been referred to as the MERS issues. But in reality, the legal issues that I'm going to discuss with you today involve many entities other than MERS, so I don't want it to be limited to just MERS. In particular, the issues that I want to talk about involve non-judicial foreclosure. And these issues are being hotly contested today in many court cases around the state. And some of the decisions that are being issued are inconsistent, and there are some consistencies. And to the extent that I can, I will try and educate you on where the courts are in agreement and where there are disagreements. Suffice it to say that this is a very complicated and evolving area of the law, and I look forward to discussing it with you and answering your questions. A little history first. For a long time, when people would buy a home, what you essentially would do is sign two pieces of paper. One is a promissory note. You promise to pay X amount of money for your home. And the second would be a deed of trust, which essentially secured the payment of the note. And for a long time, these documents would stay with the bank forever and ever until you paid off the loan. Periodically, they might be transferred to another company when a bank would merge, and whenever the loans were transferred, the deed of trust and the note would be transferred at the same time. That was the state of the law and the way things were done for a long time in the state of Oregon. Now, historically, there was no requirement in Oregon law that an assignment of a mortgage be recorded. And if you take a look at ORS 86060, it says that mortgages may be assigned by an instrument in writing, and it said that you essentially can, but do not have to, record those assignments. As a consequence, until about 1959, those kind of assignments just simply weren't recorded in order to be foreclosed upon. And I note that that's because most foreclosures up until 1959 took place in a courthouse. So there was an independent judge that would look at the title records and determine who had true ownership interest and whether the loan had been paid, and then authorize the foreclosure process. In 1959, this legislature passed what's called the Trust Deeds Act, and that allowed non-judicial foreclosure, or what's referred to as foreclosure by advertisement and sale. The legislature passed Senate Bill 117 to allow non-judicial foreclosure, but only if the trust deed and any assignments were recorded. The rationale being, if all of these documents were recorded in the county recorder's office, anyone that wanted to determine who owned the property could easily do so. They just simply had to go down to the courthouse and look at the title records. Now, Senate Bill 117 was quite controversial during the 1959 session. For example, the House voted on it 4 times and finally passed it 31-29. Now, the policy stated at the time in favor of the bill was to, quote, keep up with California, 2, to promote banking in the state, and to promote the timber industry, because if we encouraged home ownership, we would encourage more building of homes and promote the housing industry. So Senate Bill 117, which was codified as 86.735, allows foreclosure by advertisement and sale. And that means that essentially you don't have to go to court to do a foreclosure. But subsection 1 is the section that is being hotly contested in the courts today, and that is, it states, the trust deed, any assignments of the trust deed by the trustee or the beneficiary, and any appointment of a successor trustee must be recorded in the mortgage records. Now, at no point during the 1959 session was this section controversial. Both banks and citizen advocates agreed that assignments should be recorded before non-judicial foreclosure. Thus, for over 50 years, Oregon has had non-judicial foreclosure, and during that time there was never any doubt that all assignments had to be recorded to do a non-judicial foreclosure. Our Court of Appeals has recently said that our Trust Deed Act represents a well-coordinated statutory scheme to protect grantors from the unauthorized foreclosure and sale of property, while at the same time providing creditors with a quick and efficient remedy against a defaulting grantor. The court further said that due to the legislature's desire to protect the grantor against unauthorized loss of its property, a party conducting judicial foreclosure must demonstrate strict compliance with the Act. So that's the history on Oregon law. Now, technology moves fast, and MERS was created in the mid-1990s to facilitate substantial changes in the housing industry, technology, and finance. MERS is the Mortgage Electronic Registration System, and it was created by mortgage bankers around the country with the goal of helping lenders streamline the lending process and eliminate the need to record assignments when selling loans to other mortgage companies. As it became more common for original lenders to bundle the beneficial interest in the loans and to sell them off to investors, the recording process became cumbersome for the mortgage industry, and MERS was essentially created to circumvent the need to prepare and record each mortgage assignment in county land records. Essentially, the MERS system was tailored to avoid local recording requirements, and thus its immediate and practical effect was that lenders who invested in the system stopped publicly recording mortgage assignments. Now, until we had the most recent foreclosure crisis, that wasn't a problem, because if you continued to pay your mortgage for 30 years, nobody ever worried about any of the assignments. By not recording, essentially what happened is MERS would take the deed of trust in its name or as a nominee, and it was essentially acting on behalf of the beneficial interest in the deed of trust. And by acting as the nominee, the assignments could take place not in the public record, but in the MERS registration system. And MERS electronically recorded each of these assignments. And during the life of the mortgage, those assignments could be traded dozens of times. So your loan could be sliced and diced and combined with other loans and sold multiple times to other mortgage lenders. Now, generally, MERS remained the mortgage lien holder in the land, but never held a beneficial interest in the property, meaning that MERS was never owed 1 penny on the loan. They were just a nominee acting on behalf of the lender. So that's the process that MERS put in place in the mid-90s. And like I said, for a while, everything worked fine until we had the most recent foreclosure crisis.